But anyway, I am here to talk to you a little bit about advance directives, and my guess is that every single one of you has an advance directive. Is there anybody who has one that says a living will, a medical power of attorney? Who will admit to not having one? Yes, you're my victim for the whole talk. Come up front. Oh, wonderful. What's your name? Jessica. Is it okay to call you Jessica? Okay, great. You're our before and after. All right.
I cannot believe my mother is making me make this decision, because she protected me from everything. Etta, how do you feel? Etta?
Etta Mendelsohn just isn't present anymore. Not like she was when her children chose to place a feeding tube nearly 10 years ago.
She used to say yes, like, stop bothering me. But she doesn't do that anymore.
The decision was easy at the time. Although she stopped eating in the early stages of dementia, Etta Mendelsohn was still very much aware.
To let her starve to death, which is how I viewed it, and my brother viewed it at the time, she was much too part of the program. I mean, she could call me on the phone, I could call her on the phone, and it was, it wasn't like she is today, a vegetable.
Now the question becomes, would Etta Mendelsohn, kept alive by a feeding tube, want the feedings continued or stopped? Her children have no way of knowing.
My mother never, ever, ever said anything of the sort, along the lines, I wouldn't want to live if I was so sick or incapacitated. But on the other hand, she never did say, well, that's what I would want.
And my mother had a lot of opinions. Believe me, it's not as if she hadn't thought about something, but she never made one comment. Does anything hurt you?
What they do know is that if you're not prolonging a life, you're planning a death.
I would not do anything now. It's hot, summer. I mean, that's the whole thing about planning someone's death, is that you do find yourself planning it at a convenient time. That's the whole part that bothers me so much. And, I don't have any clothes to wear to summer funerals. What can I tell you, But, and my yard looks so pretty in November, but those are the kind of stupid things that you think about. I know. See, this is what's so bizarre. I hope anybody that watches this realizes that anybody would think that this is so bizarre. That how can we choose when someone should die? And that's exactly what I'm doing.
So that was Sue Mendelsohn, and her mother, Etta, had Alzheimer's disease, had it for 8 years, and had a feeding tube placed many years before. When, as you could see in that, she was still able to communicate. Time went by, and she became completely unable to communicate, was just lying in bed, and, pull the tube. Well, that's what her daughter came to me as her doctor. This was not hospice. This was actually a patient at Kivel Care Center, and she said, I want to stop the feeding tube. So question about that. Who in this state has the legal right to put a feeding tube into Etta? Is it only the person who is her guardian or her medical power of attorney? Is it number 2, her 2 children? Is it number 3, the majority of her living immediate family, including her children and grandchildren? Or is it number 4, her physician consulting with another physician? Now, you all have a little number pad, and when I say go, Not yet. Click number 1 if you think the answer is number 1. Number 2 if you think it's number 2. Number 3 if you think it's number 3. And number 4 if it's number 4. Okay, so the majority of you said that the answer was only her legal guardian or medical power of attorney. And you are wrong. Arizona says that first of all, the patient can make their own decisions. If you can make your own decisions, that's that. I, the doctor, have to honor them, unless I think you're crazy or something. But generally, I have to honor your decision. However, if you can't tell me, like Etta, then the guardian comes first. If you don't have a guardian, and most of us do not, then the medical power of attorney comes next. If you don't have a medical power of attorney, and less than 25% of Arizonans do, you happen to be an enlightened bunch, then it goes to the legal surrogate. The spouse comes first. If there's no spouse, the majority of the adult children. If there are no children, to answer you, sir, the parent. If there are no parents, the domestic partner. If there's no domestic partner, a sibling. If there are no siblings, a close friend can make the decision. And if there's none of those, and sometimes there are none of those, it falls to me, the doctor, consulting with an ethics committee. Were there not to be an ethics committee, then I would consult with another doctor. But in Arizona, there's always an ethics committee.
My husband had the power of attorney to a medical to not have extreme measures or whatever you want to call it, but chose the last minute, expressed the fact that he wanted everything done. And they asked me, because they had it legally, and I'm from Massachusetts, I said they always try once more at this time. And so they did. I can read the dials. I know what was going on. He had no function.
Let me
Pull it.
She said, and she raises a number of great points. She said her husband had a living will. And the first thing to say about a living will is it's pretty useless. Because a living will says if I am in a terminal condition or a persistent vegetative state. Many lawyers do not consider Alzheimer's to be a terminal condition, don't consider a stroke to be a terminal condition. So the living will is only going to work if you have advanced cancer. And then it does not spell out what you consider extraordinary means. So some of us consider a feeding tube extraordinary. Some of us consider it ordinary. Some of us consider going on a ventilator for a couple of days extraordinary. Some doctors say, oh no, that's pretty standard. So we doctors don't like living wills because they just don't give us enough information. So that's point one. The second point you raised was a great one. He had a living will, but at the last minute he wanted to be put on a ventilator or whatever aggressive means. The rule is, the law says, the last thing you say counts. So if you have a living will and you change your mind when the actual situation comes, and believe me, that happens often, whatever you say, you don't even have to have it in writing, is what counts. So the doctors did the right thing. He changed his mind. He said, I do want to be put on a ventilator, and they did it. Then they turned to you and said, we don't know what to do now because he's not responding. And that also makes sense because you're the spouse, so you're the decision maker. Other questions? So moving on here, all medical, well, let's do the next one. Trigger finger. Okay, now this goes to what somebody here asked. She now has in this feeding tube, just like in the video, her daughter now wants to take it out. Who in Arizona has the legal right to take out her feeding tube? These are the same 4 choices, and I'll read them again. And then you'll guess. Choice number 1, only the guardian or the medical power of attorney can take out a feeding tube. Choice number 2, her 2 children. Choice number 3, the majority of her living immediate family, her children and grandchildren. And choice number 4, her physician consulting with another physician. Interesting. Okay. So 43% of you chose legal guardian or medical power of attorney, number 1, and 41% of you chose her 2 children, and 16% chose the majority of the living immediate family, and you completely dissed the physician. Okay, so you were actually correct. The correct answer is number 1. This is the exception you asked about on your card. Exception. Only the patient, the guardian, or the medical power of attorney can make the decision to withdraw artificial administered food and fluid. This is really important because once you put in a tube, it is very hard to take it out. Yes.
Aren't the children usually the power of attorney?
A medical power of attorney is a form that you, the patient person, have to fill out and say, I appoint X as my medical power of attorney, and it has to be witnessed. So if you haven't done that, your children become your surrogates, but they're not a medical power of attorney until you've filled out the form. Does that make sense? You can appoint anybody as your medical power of attorney. You can have 2 gorgeous children, but they may love you so much that they would never let you go, so you don't want to appoint them, or hate you so much that they'll send you out. You don't want that either. So you might appoint your best friend or your lawyer or anybody you want. It can be anybody. Once you have appointed a medical power of attorney who is not your 2 children, the medical power of attorney now makes all decisions and your children have no legal rights. That does not mean that the physician won't listen to the children, because we have a little phrase, us docs, dead people don't sue, live people do. So we want to be careful. We would love to have everybody on board, including the 2 children who don't have legal rights. But technically, the medical power of attorney has the right. The second part of your question was, if you don't have a medical power of attorney, if all you have is 2 children, which was the situation with Etta, the video we watched, she could not remove the feeding tube. So what I said to her was, you cannot do this. She could not get a medical power of attorney. It was too late because the patient has to appoint her. So the only thing she could do was get a guardianship, and which takes a couple of months and about $2,000 usually. There were 2 children. You saw them on the video, the daughter Sue and the son who was a psychiatrist in New York. You want to know what happened? What happened was she got a guardianship. She went and got it and came back to me and said, now I have a guardianship. And I said, okay, now you have the right to make a decision. What do you want to do?
What if the 2 children don't agree?
Wonderful question. What if the two children don't agree? I have an excellent example of that. We had a gentleman who, this is a whole long story, but he was in a car, fell out of the car, had a head injury in Chandler, went into the hospital. His name was Jesse, if anybody's ever heard of Jesse's Law. Went into the hospital. 3 weeks go by. He does not recover. He's on a ventilator. He has a feeding tube. And so he comes to hospice. They took him off the ventilator, took out the feeding tube, and sent him to us to die with his wife's request. We realized the wife did not have a medical power of attorney, so we put the feeding tube back in. The next day, the mom comes. The mom says, "What are you doing?" I completely disagree with what his wife is doing. So these weren't two kids, but this was a wife and a mom who disagreed. The mom went to court to try to get guardianship. The court said, neither one of you can be guardian. We're going to appoint a lawyer as an independent guardian while we figure out this mess. Well, it turned out the wife pushed him out of the car in a fight. So this is true story. In fact, this is on YouTube, so I'm not giving up something private. So the independent guardian sent him to rehab. Left the tube in. He was breathing without the vent. Sent him to rehab. He recovered. He walked out of rehab. And the thing on YouTube is one of our local news stations holding up a mic to him and saying, "Jesse, this is fantastic. What's the first thing you're going to do now that you're out?" "Divorce my wife." So when you have a disagreement between two kids, the first thing I do is sit them down and see if I can bring about agreement. But if I can't, it's going to go for guardianship because we don't have an answer. What we do is emphasize over and over to whoever that decision maker is, this decision is not yours. Let's say, are there any husbands and wives here? Okay, here we go. Who wants to have Alzheimer's? Okay. Jane here has severe Alzheimer's, so you have an easy role. You don't have to talk. Jane here has Alzheimer's, and she's not eating or drinking. So, Larry, you have to decide whether to authorize a feeding tube to be put into Jane. And we do these role plays with our medical students and residents every month to teach them how to do it. And the first thing they start out saying is, "Larry, what do you want to do for your wife?"
Help her.
Ah, that's a great answer. He doesn't know. He just wants to make her better. What's important for me to say to Larry is, "Larry, I know you want your wife to live." I assume you have a good marriage, right? I know you want your wife to be with you, but our job, you and me, is to do what Jane would want. If Jane could look at herself, her old Jane, when she was completely okay, could look at herself now, bedridden, unable to speak, drooling, what would she say? Would she say, "Keep me alive artificially with a feeding tube," or would she say, "I want to be comfortable"?
She would say, "I want to be comfortable."
Then the nice thing about that is Larry has just told me her values. He did not say, "Don't put in a feeding tube," because if he says that, he's going to feel guilty. When I give these talks, people come up to me, say, 20 years ago, I took my husband off a ventilator and I have felt bad ever since. So he didn't do that. He didn't say stop the feeding tube. He told me her values. Now I can say, well, Larry, if you think that's how she would feel, and I have to tell you that 99% of people do feel that way when they look at a video like Etta, then I'm going to make the decision not to put a feeding tube into Jane. Is that okay? And he says, yes. But thank goodness he didn't have to deny her a feeding tube. So that's how we teach docs to approach, to make sure that instead of saying, what do you want for Jane? We say our job, which is in the law, in the Arizona statute, is to say, what would Jane want? That is called substituted judgment. And our Arizona law says that we need to use substituted judgment. We do not use the best interest standard, which is what's in her best interest, which is really tough. Because who is it in your best interest to live forever curled up in a bed? At least it's life. Is it your best interest to die? That's a really tough standard, but we don't have to. Except in the rare patient who has no family, no friends, nobody to make a decision. Now, there was another question that came up. What if you're pulling out the feeding tube? There is an exception, which is if there's a medical reason to stop the feeding tube, I, the doctor, can stop it. I don't need anybody to agree. So if somebody's pulling out that tube all the time, I am not going to restrain anybody. I'm the medical director for places. We just don't restrain, period. So if she's pulling it out, it's out. Whether or not it's intentional, it doesn't really matter. So the most common medical reason is that you're putting this food and fluid into somebody who's extremely ill and they can't handle the fluid and they become congested. That happens an enormous amount in hospice. So we can't feed them artificially. Or they develop pneumonia and aspiration. The most common cause of death in Alzheimer's disease is, what is it? Oh, aspiration. Aspiration pneumonia. Okay, here is Etta. Let us assume that Etta is now on a ventilator, a breathing machine. She can't breathe without the machine. Who now can take her off the ventilator? And let me add here, we know she is not breathing at all. So we know that Etta will die when we take her off the ventilator. Who can do that? Same four choices. Number one, only her legal guardian or medical power of attorney. Number two, her two children. Number three, the majority of her living immediate family, those children and loving grandchildren. Or number four, her physician, consulting another physician. Who can decide to take Etta off a ventilator? You did that for your wife. Very, very brave thing to do. Okay, this is confusing. It's a confusing and interesting part of our Arizona law. And by the way, this is only in Arizona. This does not apply anywhere else. If you take your card, the only exception to this hierarchy was removing a feeding tube. So taking somebody off a ventilator can be done by the guardian if there is one, but if there isn't, the medical power of attorney. If there's not one of those, the spouse, and if there's not one of those, the children, and it goes down the regular hierarchy just as for any other medical decision. So just because she's going to die does not mean it needs a guardian or a medical power of attorney. We have a very interesting country. We're the only country where the default mode is to put somebody on a ventilator. You don't have to choose to be put on a ventilator. It's going to happen unless you say no. In other countries, you have to ask to be put on a ventilator. The correct answer to this is her 2 children. So it's just the same as putting in a ventilator, putting in a feeding tube. This is a summary of the law we've just talked about, that this is what's on your card. Now, let me take one more question here. I'm running short. If the decision is made to remove the feeding tube, and I think this is really important, how will Etta die? Number 1, starvation with significant pain and suffering. Number 2, she will die from aspiration pneumonia. And in aspiration pneumonia, people just swallow their own saliva. It doesn't have to be bugs from outside in the community, with significant shortness of breath and distress. Number 3, Etta may not die. She'll be able to eat on her own when she gets hungry enough. Number 4, she will die from kidney failure due to lack of food and fluids together, gradually drifting into sleep without pain. Wow, great job. You are correct. You are better than our medical students. I am proud of you. They often say that she will die of starvation. And it's really important that they understand, you understand, that if you stop eating and drinking, it's actually a comfortable death. The only way that you would die of starvation is what we used to do when I was in training. Everybody died when they died in the hospital with IV fluids. So they'd get hydrated with artificial fluids, but no food. Well, starving is not comfortable. But dying of dehydration is actually, this is a great conversation, isn't it? It's actually comfortable. You drift into kidney failure, and there are endorphins that are put out when you're in kidney failure, so your pain actually diminishes. So our goal, and many oncologists' goal also, is to have people die from kidney failure, just not eating and drinking together. And you just drift into sleep. It's comfortable. You can be in your own bed. You don't need anything artificial. So that's the most easiest way to die. So it's important to tell people, if you're removing a feeding tube or if they can't eat or drink, to understand that that's comfortable. We don't need to do anything medical to fix that. What should you do now? Oh my gosh, what a great question. First of all, number 1, 2, 3, 4, and 5, and 6 is have a medical power of attorney. And don't just have one, but talk to them. Tell them what you want. Tell them your values. And don't just talk to your medical power of attorney, because they may not be the ones in the emergency room when you end up there. So you sit down with those recalcitrant children of yours, or your siblings, or anybody who might be around, and your doctor. But unfortunately these days, the doctor you have in the office is not going to be the hospitalist in the hospital. And tell them what you want. Or more specifically these days, what you don't want. And make sure they know, because they're going to be your advocates, standing up for you when you can't talk. The other thing you do is, if you have specific requests, put them in writing and have it witnessed. We have a great law for witnessing. A witness can be anybody except a blood relative or a beneficiary in your will, or somebody directly involved in your care. The doctor can't be the witness. But you can have your next door neighbor be your witness. Write it down. Clear as a bell. Hospice of the Valley has a group, a